It says it's setting it up. I think we're almost there. There's Ms. Boyson. Are we on now? Setting it up. No, I'm still getting, well, maybe not. I think we're almost there. Yeah, I'm getting the delayed. There's Ms. Boyson. Are we on now?
I'm showing the live stream. I can see it.
Right, but I'm getting a delayed echo of my own voice.
Okay, there's a window you have to close out.
Where is it?
On the right-hand side, I'm showing the live stream. I can see it.
Where? Right, but I'm
On the
getting a
right-hand
delayed.
side.
Where?
Of the window. Okay, there's a
What do I
window.
look for? Where? What do I click on, Melissa?
There's the window.
What am I looking for?
An X, the gray X.
And where is that supposed to be?
On the right-hand corner.
A gray
Top
X?
right-hand corner
Okay,
of the computer screen.
all right. Now this may have finally done it. Ms. Wilson, does it appear that we're live? What's that? On? Ms. Boyson, can you hear us? Okay, let me increase the volume here. And Melissa, the volume control is found where?
I believe on the very bottom of your computer screen on the right-hand side.
There we go. Okay, for some reason I'm not. Now, Ms. Boyson, are you muted? I'm not hearing you. Can you hear me? Okay, so she's hearing me, and it appears that the other users here believe it's live streaming at this point.
Yes, it is.
Okay, so maybe it's just a problem now with Ms. Boyson. Okay, she's trying to communicate, but let me start with the other case, and that is State v. Dorset. Mr. Nagel for the defense, Mr. Maresca for the state, 19 CF 2116. Mr. Nagel, are you waiving Mr. Dorset's appearance?
Yes.
All right. And Ms. Brown for the state. Greetings. This is here on a joint state and defense motion for an order to show cause.
Yes, Judge, I believe an individual in the courtroom with a badge from NCA.
And who is it that we're waiting for? Greetings. And what is the name, please? Okay, Dr. Lopez, could you come up and go to the witness box, please? Could you have her sworn, please?
Dr. Lopez, if you face the clerk and raise your right hand, please.
Do you swear or affirm that the testimony that you give shall be the truth, the whole truth, and nothing but the truth?
I do.
Okay, greetings, doctor. Please come up to the
Okay.
witness box.
Thank you, sir.
Thank you for appearing today. Mr. Nagel, well, this is actually a joint motion. Does either side wish to lead off?
Well, Judge, I mean, the situation is simple. We need to get to the deposition of Dr. Lopez. She's here today. My plan is to depose her after court right now. If she's going to do that, I don't see the need to proceed with this matter.
Your motion indicates, it's a joint motion, actually. Your motion indicates there has been some difficulty with this?
There has, Judge, initially, back when the tendency of this case started, and I set the initial deposition, including Dr. Lopez, we had contact from her office. Her assistant indicated she had not treated anybody in the case and had no idea what this was about. Based on that assertion, we canceled her deposition then. As we moved to this year, the case began getting closer to the trial date. I went back again and contacted their office again to double confirm again that she had no involvement and had not dealt with any witnesses. And I listed specifically the child victim's name in this case. At that point, their office indicated, oh yes, they actually had done the treatment with this child. I said, we need to set the deposition. I had an additional date. Her office asked for us to confirm with her about potential schedule dates. We sent potential dates over. We never got a response from her office. I set a deposition without a response. the doctor was unable to attend that she was working that day. I reset the deposition again of the doctor, again contacted her office with potential date and asking her to check the calendar for availability. You're not getting a response. Again, I had set it by unilaterally set a date. Doctor was working that day, was unable to attend. All I want to do is get the doctor's deposition.
And how long of a period has this been going on?
Well, the initial mistake, I'm not going to include, going back to the case defendant. The two sessions that we've had this year, both been this year, so within the last 6 months.
Anything else the defense wanted to add?
No, Judge, as I said, all I want to do is get the deposition done, and that's all I have.
All right, before addressing the doctor, this was a joint motion. Does the state have any comment?
Your Honor, unfortunately, as you know, the motion and the request predates my involvement in the case. I was looking for the subpoenas for the deposition for the doctor, and I couldn't locate them on a cursory review of my file. So I'm going to defer to Mr. Nagel in court, seeing as I wasn't involved at the time these issues were addressed and the motion was made.
But Mr. Maresca, your predecessor, did sign, I see, on the joint motion.
And unfortunately, I just don't see in documents the motion, so I obviously,
But the state agrees that the deposition needs to go forward?
it does need to go forward. She is a listed witness, yes, Your Honor.
Any other state comments?
No, Your Honor.
Doctor, at this point, what seems to be the difficulty?
So I think the problem is multifactorial. Our office is actually in Coral Gables, and I think it's a lack of communication with them and myself. I have no problem giving the deposition. In fact, I've given multiple depositions for child abuse cases. I'm a pediatric critical care doctor. That's what we do for a living. We take care of sick children, many times, unfortunately, victims of non-accidental trauma. So I have no problem giving the deposition. I think things got lost in translation, or with the pandemic, everybody's been busy, but I think a major component of this is that our office is in Coral Gables. I think there's lack of communication between them and us. And
But
there's
you're-
no excuse, but we can do this now. I have no problems.
So, Mr. Nagel, you and Ms. Brown are able to address this today?
Once we've done the remainder of our court schedule, we now do a motion that we're adding.
Now, the other option, of course, this case is on the jury trial
It is
side.
on the jury trial docket, Your Honor, and Ms. Brown is involved in this case as well as the case at number one, is that if she's involved with that other case, she's not going to be able to deal with this case. Additionally, we are still in the process of we're talk once we get through the next couple of court days about possible resolution of the case as well. As I said, my original plan was that this week you have a motion, I go do the deposition immediately with the documents available. I am still going to do that, but now we do have additional court matters that we have to address today.
Ms. Brown, what's the state's preference based on what is occurring?
Your Honor, I am available to do the deposition now. I do have another court appearance, I believe with Your Honor and Mr. Nagel at 3 o'clock, but I don't have anything between now and then if the doctor is available. Otherwise, Mr. Nagel and I will work with the doctor to pick a date before she leaves if we're going to set it in the future. Again,
Doctor, do you prefer to try to do this today to get it?
I would prefer we do it now. I mean, if we can get it done now, let's
Mr.
do it.
Nagel?
I've still got another motion besides the one that I'm up with Ms. Brown, Judge. If you can get those matters straightened out, then.
Those, I believe, those matters are later, though.
Are they later, Judge? The second one I thought was 1:30 still, the Brown matter.
Brown is at 3:30.
I'll be on at 3:30, Judge. The initial notice I saw from your office, I thought it became 1:30. If that's the case, then,
Okay.
then again, I'd ask you to.
So, Ms. Brown, based on our schedule, you would be able to address this now to avoid the doctor having to have
Oh,
our
absolutely.
schedule in?
I'm not trying to.
Well, Doctor, thank you for being here.
Thank you.
We appreciate the care that you provided the community, especially in the pandemic circumstances. The reason, though, it rose to this level is that we do have a fundamental constitutional right involved here,
For sure.
the right to compulsory process, both in the United States and the Florida Constitution. And every defendant, and frankly, the state of Florida also have the right to have witnesses present themselves to be examined. So I understand things are complicated in what you've explained. So obviously we can do this cooperatively.
No
Thank you
worries.
for your explanation. I'll let counsel then leave at this time with the doctor to get that done so we don't have to impact you anymore. Thank you for being here.
Thank you, Judge. We'll see you guys when we back.
All right. Very well.
Thank you, sir.
Have a good day. Correct. So, Mr. Nagel, I'm dismissing the order to show cause at this time.
I'm sorry, was that?
I'm going to dismiss.
Oh,
or-
absolutely,
Right.
I agree completely with that.
All right. Ms. Boyson, can you hear us?
I can hear you. Can you hear me?
Yes, you're coming in loud and clear now. Very good. And good afternoon, Mr. Finglass. Welcome. Mr. Finglass, you want to come up and have a seat at the table, please? Welcome back, Mr. Finglass. We are here for two purposes, Mr. Finglass, and let me begin by saying that I believe you have strongly asserted, as is your right, to your, that you are not guilty of the charges that have been brought against you.
Absolutely, sir.
And I know you feel strongly about that.
100%. We have original video, and we got it in West Conway. Mike Adams is the owner of McDonald's. He knows me. We made a call for him, and we're gonna see if we can get him in here. He's got video.
I'm sorry, let me just make sure the state is here. Is Ms. Wilson or Mr. Ashby, who's covering this?
Mr. Ashby is in the deposition, Your Honor, so Ms. Wilson will be covering it. She's just taking down some notes that Mr. Ashby emailed me,
Okay,
that I'm not able to, for some reason, to email her.
okay. Are you able to do both at the same time, Ms. Wilson?
Your Honor,
Okay, all right.
while Ms. Wilson takes them.
All right, so, Mr. Finglass, obviously, at this point, you have strong feelings, and I understand those, about your being not guilty of these charges.
100%.
And the way that can be determined is by having a trial in your case, as long as these charges are pending.
I'm not taking video, we got the original. Would that be okay?
Well, that's something that Ms. Boyson can show to the state.
Her video, she showed me, it was Snow White, and she couldn't read it well.
Right.
And Public Defender Sarlo saw it with Tamara Wilson, and I was free and clear. I never touched hers
Right.
under there.
No,
So
I
there is
understand.
lying on the police reports. I did do an addendum.
Let me just
Sorry, go ahead.
Yeah.
I did a lot of work behind the scenes. No one's acknowledging my intel work that I did.
No, and I understand that, you've done a lot of preparation on this case. You feel strongly about it.
Yes, and I called 911.
What I want to understand, you to understand for today though, Mr. Finglass, is that in order for you to be found not guilty of these charges, it has to happen one of two ways. Either Ms. Boyson negotiates on your behalf with the state and convinces them that these charges should not be brought, or if they're not willing to do that, I don't control whether the state charges.
I have.
One moment, please.
Sir,
Okay, I'll come back to you.
I got evidence.
Okay, but
Video.
here's the thing. The other way, if they don't drop the charges, the only way you can be found not guilty is by having a trial, where you can present your defenses and they present the charges.
How about we call Bruce Wood in here? The canon law says when you have a big case, bring both witnesses in and make a good judgment.
Right.
And
So we have to
Bruce is
have-
not confident.
Right, so we have to have a trial, is my point.
Let's bring him in.
Here's the problem, okay? And the reason we're here today is I can't do a trial if I don't have you do the evaluation to make sure that you are fit for trial.
Sir, I had an evaluation with Dr. Wing. Now, what about that? And then I was held captive in Virginia when I went to go save my son's soul, and I was locked up in a rehab. And Leslie Wildenhammer had a lot to do with that, and my card got thrown away. Now I'm gonna have a new small claims court, so I gave some evidence to Rambos. I'm being published with the legal department. And I'm seeing a psychologist here. And I've got appointments back to back. Now, I've been.
Is that with the Veterans Administration?
Yes, I have. I'm
Okay.
dealing with the legal department. They're gonna be talking with Tamara Wilson. They're gonna be talking to Crystal. They have a letter they'll be sending to you. I just want my freedom. If I'm mental and I started a piece of land and I called it Nature's Nursery and the director, Dan Beebe, did it, and now my nursery is being taken away from me and everybody's trespassing the land.
What makes you reluctant to want to speak with the appointed doctor to make sure you're
Because I passed with Dr. Wing, I had a panel of 12 doctors out of state.
right?
They let me go.
But that was a while back, Mr.
That's okay. I am a enlightened pastor. I am a gifted man. My son's gifted. Do you know what an enlightened pastor is, sir?
I think
Go
I
look
do.
it up. I have a lot of healing skills, and I healed Bruce, and I'm healing
So,
somebody now. So I'm
Mr.
a healer.
Finglass,
I'm not mentally incompetent.
Let me just explain.
Okay.
The law requires,
That's good for the law.
one moment, the law requires that I have you evaluated to make sure we can
How
go forward
about
with the
the
trial.
attorney that has narcissistic personality disorder, and how about my wife that has personality?
That's very
disorder?
unfortunate.
June 1st was the World Narcissist Awareness Day,
I wasn't aware of that.
and DeSantis' wife has a $25 million program to help kids with school and through these things. Now, the doctor, that was a blessing that the doctor was there because my son's been abused. And if you go back to the records from Judge Brody, you'll see in 2000 that I put a restraining order on my ex-wife, and I've been fighting.
But Mr. Fingerlass, you understand, no evaluation, no trial. And that's a problem.
And we're gonna send some people out to Bruce Wood's house and see how his mental stability is, because he's bipolar.
All right,
He's
let me
50 years
stop
old.
there for a moment.
And he's attacking me with Patterson right now, and we got him on camera. Would you like to see the video, sir?
Not right now. One moment. Ms.
I'm getting
Boyson.
trespassed right now.
Okay, one moment. Ms.
Not
Boyson,
mental threat.
you have a motion to withdraw, is that correct?
I do, Your Honor, and it is regrettable. I do like Mr. Finglass, but with everything going on with Mr. Zutton, I can't really chase Mr. Finglass around when I'm going to be, locked down with trial and Zutton, and I don't, of course.
Let me ask this, do both the state and the defense agree with the court that even though Mr. Finglass correctly remembers that he was found competent by Dr. Ewing some time ago, because,
And also out of state.
Mr. Finglass, I don't interrupt you, please don't interrupt me, okay?
Yes, sir.
But because so much time has passed and the issue has been raised, the law requires that I do have him evaluated and we can confirm that he's ready for trial, and then we can have the trial and he can be found not guilty if that's what the evidence
Sir,
shows.
I'm gonna be evaluated with the VA. Is that clear?
Well, Ms. Boyson, do you know if the VA can do such an evaluation?
I don't have any legal basis for that. It
Nothing too much.
has to be somebody off the court-appointed list, which is why Dr. Arias has been appointed. But I can't seem to get the two together. So
Is there a reason, Mr. Finglass, you won't cooperate with Ms. Boyson?
No, because I have my own doctors. I'm seeing the post-medical stress disorder team. They have a special unit. I'm also going because I got tased on 225 by my bail bond girl. I let them go. I stopped Dyke's case and I stopped all the sheriff's cases.
Now, you realize,
I
Mr.
let the cases go, sir.
Mr. Finglass, you realize that any doctor that we appoint can talk to your doctors with the
No,
VA.
I'm gonna go with my medical. That's why I'm going with the legal team. They're gonna be contacting.
Now, Mr. Finglass, do you realize it's not your choice in this?
Sir, I have a choice. I'm an empath and I'm psychologically independent. Okay? I'm at 5D technology and most humans are at 3. You have a debate about that? Let's go talk to the doctor.
Well, I'm glad you're at that elevated level. That's very impressive.
I'm very
But
good at what I
it's
do.
still not your
All
choice,
I do
Mr.
is
Finglass.
heal.
All right, so here's what I'm going to do. Ms. Boyson,
I don't like it overriding.
Do you have
my
any-
medical.
one moment, Mr. Finglass. Do you have any ethical reason to withdraw at this time?
Better with-
ethically, only that I cannot contact him. I did ask for his phone number last time we were in court. He gave the same Proton email.
But you don't have
On-
any other legal or personal conflict of any kind?
I don't, except that he's just not working with me. If he doesn't want my help, I can't help him.
Emails from January 20th. May I send them to your office?
So
sir?
here's what I'm going to do, Mr. Finglass. This is the way it's going to
I
work.
make contact with people, sir.
This is the way it's going to work, okay? I'm going to give you a final opportunity to cooperate. And that means that you are ordered at this time to communicate with your attorney, provide her contact information, and work with her to arrange for Dr. Arias to evaluate you. That evaluation will need to take place. I cannot have the trial by law without that evaluation taking place.
Who is this doctor and where is he at?
Dr. Arias does a lot of evaluations for the court for both the
Let's
state
get
and
him
defense.
up. Give you the name and the number, and I'm gonna call legal as soon as I get out of here, and the VA will be contacting you. They're gonna take care of it.
So you're ordered further to be participate in that evaluation. I'm going to set a court date in a moment to come back and see where we are.
What about the bail, $15,000, sir? I don't have that.
That's Manalich's office.
Melissa, for Mr. Finglass, we need to set a date approximately 30 days out. Ms. Boyson, at this point, I'm going to continue your motion to withdraw
That's fine.
and see what happens between you and Mr. Finglass. I will allow you to raise that at the next court date. I've ordered Mr. Finglass to cooperate with you and provide you contact information as well as with the scheduling of the evaluation so that his claim of being not guilty can be heard at trial if the state, after reviewing his evidence, chooses not to drop the charges.
Very good.
And Mr. Finglass has been ordered to cooperate with that evaluation. I'm going to set this for a status update. In 30 days, Mr. Finglass will be given a copy of the notice he will be required to appear. If Mr. Finglass does not cooperate with counsel with the evaluation, then he will be facing contempt of court and may be subject to being jailed until he is evaluated. But I don't want to do that. I'm hopeful that we can do this cooperatively. So Melissa, what would be that date? And we'll check with counsel and with Mr. Finglass.
July 21st at 9:30.
So let me begin with counsel. Any problems with July 21st, 9:30?
I'm checking because I'm hoping to be there in person. I have a pretrial conference on a homicide case at 8:30.
In another county?
Yes, in Lee County.
All right, so Melissa, let's move to another date.
How about 3:30 that afternoon?
I can do 3:30.
Ms. Wilson? July 21 to 3:30 p.m.
I will put that down on our end.
Mr. Finglass, any reason you couldn't be there on that date?
Where's this?
For you to come back to see how we're doing and if you're following?
Where?
Yes.
Okay, what about the
About the what?
doctor?
You are required to work with Ms.
So you
Boyson.
gave me the number, she changed her number 3 times, and I sent emails and I realized, would you like the dates of all the emails that I sent?
No, I believe you.
Because I'm always organized.
Ms. Boyson, what is the best way for him to communicate with you?
He knows. He has my personal cell phone number and my work phone number. I've had the same phone number since 2002 and gave it in open court on May 6th.
Let me have you, are you willing to restate that publicly on live stream, or do you want to keep that private?
I stated it last time on May 6th in open court, 239-272-7442. But Your Honor, I'm going to tell you, this is what he did the last time. He calls me the day after court, leaves me a message, and says to pick up my phone at 9 a.m. I don't sit by my desk. I'm running through the airport trying to pick up discovery and kept my phone from 8:45 to 10 a.m. and he never called.
So, Mr.
So
Finglass,
he needs to give me a phone number.
The last time I called was January 23rd.
Right.
and
I understand. Mr. Finglass, just as you deserve respect and are being given respect by the court, and obviously I'm expecting that, and I always get that type of behavior from Ms. Boyson toward you. I mean, she's going to treat you with respect, but you need in return to respect her schedule and call her and coordinate in a way that both of you can cooperate and prepare your defense together. So
Monday, what about the $16,000 bond you have me hostage on?
what I will do, Mr. Boyson, Mr. Finglass, you apparently posted that bond, right?
I did in some church people.
Right, okay. What I will do is this. I do think he raises a valid point because there may have been some type of misunderstanding when I think it was a missed court date, and I do think that's important. What I will do is I will entertain a motion on the return date, Ms. Boyson, for the bond to be reduced to an ROR where he can have the funds released.
I was purged out last time with Hammer and, where was it?
No, I didn't.
Okay, go look up the dates from 3/20.
But what I'll do, Mr. Finglass, when you come back,
Yes, sir.
I will address the bond for you.
I have no money, I got $100 in my
Right.
name right now, I wanna work on my nursery. I would like for you to call property appraisal, we'll see what that,
Well,
whatever.
Ms.
Get
Boyson,
that back.
why don't you find out what his bond situation is, bring the appropriate motion so that the state has a chance to respond, but I will address that for Mr. Finglass if that will help him at the next court date. But Mr. Finglass, just as I'm reaching out to you, I need you to reach back
Okay,
and
I have a
cooperate.
question for you, Manalich. My question is, I did tell you Patterson was attacking me. I did put motions in with Martin. I want you to speak with her. She said to go our own ways. I've been away for 1 year. I've not talked to Bruce.
Well, one of the things that can happen, Mr. Finglass, is if you speak to Ms. Boyson, a lot of these things, if they
She
are,
won't talk to me.
well, gotta make the effort.
I will make the effort right
Okay.
away, but I'd like for her to call back or email me back what's going on.
Ms. Boyson, any other requests?
I would just request a phone number that we can test while he's in court so I can contact him.
I just got a new hotline and it's private due to I'm being stalked.
Alright.
I have a right for that.
So you're telling the court now on the record,
I
Mr.
know
Finglas.
I have a email. She knows it. It's the same one. It's never changed.
Well, it's been problematic, so,
No, sir. It's operational now.
well, I'm, again, I'm not gonna micromanage, but I am gonna say that
It's working.
you're ordered to reach out to
Whatever you
her.
need to, I want to get this over with.
Okay.
Yes, sir.
All right, well, this is the quickest way to do it.
Let's get her done, sir.
Melissa gave us a court date.
Yeah, I have it, I just want to give you a copy of this.
What is this now?
Everything.
Yeah, this is Dr. Arias's order, Mr. Finglas.
I have his name and his contact number, sir.
Okay, you don't need a copy of this then?
Yes, I'd like that.
Okay, we'll give you that.
Absolutely.
Thank you for being here, Mr.
Thank you,
Finglas.
sir.
We'll see you in July, and hopefully we can keep this moving. Have a great day. My salutes to you. In return. All right. Thank you, Ms. Boyson. You're still on the job.
Thank you, Judge. I appreciate
All
it.
right. Hang in there.
Thanks.
All
I'll
right.
see you on the 28th. I do have the closed situation all worked out for Mr. Zutton.
Very good. Thank
So I
you.
appreciate it. Thank you.
All right. We next move to, I believe Mr. Richard will take a 5-minute break. I know I saw him here earlier. Ms. Rumley, hello. And we'll get started on the Richards matter in just a moment after 5 minutes.
All right, court is recessed, 5 minutes.
I'm surprised the judge had that much patience.
It's a steady impasse. He's an empath. He's an empath. He's healing somebody. He's an empath. If he thinks there's what's that? Well, it's a people are empath. He's an empath. Yeah, he's a 6D. Yeah, he's on 6D. We're only on 3D.
We still might be live feed.
Oh, shit, after that, there's nothing we can
You can't beat that last one. So, no matter at this point.
Yeah, we are now, boy.
At least you're healed up. You can't buy that kind of entertainment. Oh, like a Springer live show, triple X version.
I wanna go back to my game.
There's some,
I was gonna become boring. Yeah, it's.
James Dillon will be boring. Right.
Well, we should have saved that one for last.
Yeah. As Marty Fife said, he's like, hey, you can teach good.
I was trying earlier, but I'm wide awake. I can't stop waking up. Well, just, you know what?
Man, we got a continuation of what we
So what
were
is
doing.
all this good on everything?
I don't see saying my name.
Push everything in the
No, really?
That's because he's
Actually,
that's because he's level
that,
5.
yeah, on.
I can't wait to get these motions done.
Yeah, well, it could go through.
This case could have been over with 3 years ago.
That's a- I'm just trying to-
Yeah, you could have did it 3 years and then,
That's been a little bit higher.
Yeah, he's a 15 year.
oh, my.
Still good right now.
Did he say he was a 4D or a 6D or? Is that, yeah, is that like a 3G network
I don't-
versus a 5G network? But Mark is a 6. I think he does I only like my little one-dimensional world. I like everything.
That's why you operate at 3. That's why you operate at 3.
Oh, really? One. He's a 1. I'm a 1. Maybe not even that much.
0.5.
If I'm lucky. If I'm lucky. Mr. Richards, just set in the galley for right now, till we come back in the session.
Level 6D. You better read 7D. Get 7D. You better read. If I get to 8, you start hovering. I levitate. We'll start seeing smoke come out of the ears. Not a line. Start hearing the wall.
We won't be able to see any of that.
Will it be like a turbine?
That's just.
Here's what happens.
Will it be like a turbine winding up?
No, because I put you all in a time-lapse environment, you won't see me doing what I'm doing.
Oh, looks kind of like the Flash.
You won't even know, I'll still be over there. Just happen.
Brian showed me the weightless things.
Levitating. He goes up and down, sitting in that chair.
Well, that's just his head.
Yeah.
That's just his head. Nothing there.
Alright, hold on, I'm gonna try to reconnect you, otherwise I might need you to text me or something in or come down. Okay, wait, hold on. Yep, I got it. You got it? I got it.
Pass on some of my levels to you. I'll be right back. That's only to me. That was 5 minutes, right?
Yeah, we're about 5 minutes.
We have a nice supply of the world's finest Chinese masks.
Oh my God. Yeah. I love that too. That's a level 7.
My name is Sir.
Oh, all right. Nice to meet you. Yeah. After that.
We're looking for
He's lost. Mr. McClure, how you doing?
This person.
He's good. You got Mr. Richards, attorney.
Here I am.
He asked me to come. Yeah. I told him I let him know the doorstep was waived, that sign will get with you later. I told him. We still have 2 back there. To be held. Their cases are at 3 and 3:30. It is.
Yeah.
Over there then.
Just can't rush this.
What? You can't rush these things.
Take time.
It's a lot of fun.
Fast money is not that easy money.
You were level 5, you have a better understanding
Oh.
what the process is.
You are not very enlightened.
Okay.
You need to be one.
I mean, and I've done a lot.
You know what that means?
Money to do right now.
Nobody knows what that means, you made it up, but.
Do you know what that means? Oh my God.
Yeah,
you know
because
Oh, I didn't
She had him,
Nailed this from the flat part.
I'll be right back.
that's what I planned on, yeah. Yeah.
Have access to a computer that day.
That's fine. So here's the Christopher.
He's up in Tennessee, he's part of the entry team sport team.
Easy test.
Don't have to try
Jeremiah, Jeremiah J. Carroll.
They think Carol, I think, might have been someone. Oh, he was our, we removed JJ Carroll, Mike Carroll, and Carroll was added, like, we had listed the wrong person. So they didn't go now. He's not on the list. So,
Scotty.
that's why. We haven't been on it.
He hasn't.
Yeah.
Carol A. Green,
So,
Jessica and Christopher.
yeah, she's specified 4 rings, one of them is yeah, and I like to get all those done before that. So next week, maybe next week we can go on.
Gotta rise to 5D, man. Gotta rise to 5D.
Thanks, Mark.
Oh my God, this is
We're like a 10 and 0.
No, it was 3 to 5. This is crazy years. I was like 3, but he's 5.
All rise, Carter County Circuit Court is back in
All
session.
right, welcome back, everyone. Thank you. Please be seated. All right, next is State v. Richards, 16 CF 82-B. Mr. Richards and Mr. Ermacora are present. Mr. Ermacora is standby counsel. Mr. Richards is self-represented. Welcome back, Mr. Richards.
Good afternoon, Your Honor.
We have a slate of motions this afternoon. Let me ask, do the parties want to address the continuance motion at first, Ms. Remley?
No, but I think we should do the rest of the motions first, because obviously if the court is inclined to reserve on anything, that may change the continuance request for the minutes.
All right,
So I think we should maybe get another continuance at the very end.
Mr. Richards?
I have filed a petition for depositions, and I need to do these depositions, so I feel I have abandoned the continuance until these depositions are complete.
So you're asking for a continuance, correct?
I guess that's what it takes to do these depositions through my petition, yes. Yes, Your Honor.
Who are you seeking to depose, Mr. Richards?
Well, I was just informed Jeremiah J. Carroll, I guess, was substituted or something, so he shouldn't be a part of the list, but I guess Christopher D. Swarthouse, John A. Pepin, Carol A. Raines, and Jessica M. Gerster.
And are these all law enforcement?
They're all sheriffs and they're all category A, and the Urban Corps did advise me that I do have the right to depose anybody that's category A.
They were not previously deposed?
To the best of my knowledge, no, I have no transcripts from them. I
Okay.
can't find any paperwork that they were deposed, Your Honor.
Ms. Rumley, do you know if they were previously deposed by prior counsel?
Judge, one of them was previously deposed. Mr. Richards, would you mind repeating that list, please?
Yes, Christopher D. Swarthout, Scott A. Pepin, Carol A. Raines, and Jessica M. Gerster.
I believe, Judge, and I just one moment, I'll look up that was done.
And you say they are all listed as so-called category A witnesses, Mr. Richard?
Yes, Your Honor.
Let me just,
Those four witnesses, Your Honor, have not been deposed. Adam Carroll was deposed. He was the one we substituted for J.J. Carroll. So there are four witnesses, and Mr. Richards, prior counsel, have not deposed yet. One of them is a former law enforcement officer, just finding out from court liaison where he lives, I think it's Tennessee or something like that. Out of the witnesses, Mr. Richards wants to depose. Two of them are were from the entry team of the SWAT team that originally entered the defendant's house. The state does not plan on the trial. The other two are fingerprint analysts currently employed with Collier County Sheriff's Office. And I'm confident we can coordinate all those depots with the assistance of Mr. Cora, who was kindly offered to assist with that prior to the trial date.
so the state does not oppose the motion to depose?
Judge, I don't believe I have a legal basis to do so. However, I'm not accepting that myself as a reason for continuance in this case, as the case is almost 6 years.
Now, would these individuals be available on short notice between now and the trial cycle?
Judge, I believe if we can do Mr. Swarthout, who's no longer with Collier County Sheriff's Office and resides out of state over Zoom, that might be possible. Ms. Raines has leave, but it's not until currently after the trial cycle. Ms. Gerster has leave, but it appears she'd be available prior to the trial cycle after June 20th. And Corporal or Sergeant Pepin would be available before the trial cycle. So yes, I think you could accomplish that.
There is one out-of-state witness, is that correct? Is that witness being called by the state at trial?
No, Judge. Again, he's one of the entry team for the SWAT team that originally went into Mr. Richards home. The state doesn't have the state calling the trial.
Mr. Richards, do you have any objection for the out-of-state witness to do that by Zoom or remotely?
I do not have any objection to depose and question anybody that's not local. But how realistic, how fast am I going to be able to get these depositions and review them? That'd be my question. Because when it comes to the fingerprint analyst, there's a need to, I mean, there could be subjective fingerprints involved with all that. I don't want to get into all that right now, but
So you're saying you would like to be able to order transcripts and review the, and have that preserved for use at trial?
yeah, the fingerprint analysts, for sure, because I think with the other two, I think we're going to get the same rhetoric, but for the fingerprint analysts, I think we're going to find out some more information, Your Honor.
Okay. All right. I think that addresses that motion. Is there anything else about that motion that needs to be discussed?
No, I think that.
Ms. Rumley, anything on that motion? So the state is saying it would prefer to try to get that done in coordination with Mr. Richards' schedule prior to the trial cycle commencement, and he's indicated he's willing to do by Zoom the one out-of-state witness.
That's accurate. The state, again, Mr. Richards has chosen to represent himself at this late stage in the game. We're set for trial on June 28th. If we continue the trial, it will be the 15th continuance over the course of 5.5 years due to issues like this. And at this point, the state is not willing to agree in any way to a continuance. We're ready for trial on June 28th.
Well, let me
We'll make
continue.
ourselves available
Right.
pre-trial for those depositions.
Right, but I think we've addressed this motion. I'm going to rule on the continuance at the end. So let's continue. What do you wish to address next, Mr. Richards?
I do have a motion to reimburse cost for required transcripts. I did file an amended one and a regular one, because I wasn't sure if it should be amended or not after your last order. And I did, oh, sorry.
I do think the court already denied the motion for continuance and for costs. I'm seeing the last docket item in this case, Judge, on June 8th, Your Honor.
Right. I did allow Mr. Richards, however, to amend it,
Yes,
and
and the order was written, I just didn't have time to come here and file it and amend it and update it the way, that it needed to be worded. I don't-
so, Mr. Richards, basically, what have you done in regard to that motion with the JAC as far as any coordination with them?
At this point, Judge,
Yes, that's fine.
I spoke with Mr. Richards outside court with respect to that. After I had read your order in May, because the last time you were here, you suggested to do that, and provided the reasons. And I explained to him the procedure. Your Honor said the court doesn't take costs, the JC pays them. The court just orders the JC to do it. And I explained to Mr. Richards the procedure he has to follow. He's got to serve his motion on the JC, wait for the response. Normally, they never object, they just take no position. When they do that, you can file a motion with Your Honor, and Your Honor would normally just sign that motion if the JC doesn't make an objection to it. So I explained the procedure to him. In fact, he doesn't really need a motion here today to deal with that aspect.
So are you willing to do that, Mr. Richards, and
Yes,
follow
I have
that?
the email here, I'm gonna do that, this afternoon.
I provided him with the email address for service of the JC, so he has that now. I told him
Now,
to go about it.
These things that you're requesting transcripts for, I believe it's a motion, 2 motions to compel and a motion to suppress, is that right?
Yes, I did receive the transcripts already, I just need to be reimbursed for them.
Okay, so you already have those transcripts?
Yes, Your Honor.
All right. So it's just a matter of reimbursement.
Yes.
All right. So that really doesn't affect the trial going forward, because you already have those.
Yes, Your Honor.
All right, very well. Next one, Mr. Richards?
I guess that would bring us to the, motions to dismiss and compel.
Okay. Which one first?
I guess, I'm gonna go throughout both of them, I guess we can hear both of them at the same time.
Any objection, Ms. Roma? Do you wish to have them separated?
Yes, Judge, they need to be separated, please.
Okay.
We could hear the amended motion to compel first.
All right, can you address that first, Mr. Richards?
Absolutely.
Thank you.
Just a second.
Yes. And do you know when that was filed?
Judge, the latest one was filed on March 15th, 2021.
Let's see if I can locate that. I think I found it. So this is an amended motion to compel. And I have that now before me from March 15th. Is that right, Mr. Richards?
Yes, Your Honor.
All right, go ahead.
All right. For 5.5 years, the state has been unable to produce one shred of evidence to verify the credibility of any assumed confidentiality or existence of probable cause evidence to accommodate the totality of circumstances of the affidavit. The only illusion of credibility the state has mustered up so far came from the benches offering a prima facie value to an otherwise invalid affidavit. A prima facie value that I may add is equitable to nothing more than hearsay. We have given great deference to the affidavit, but after the defendant in his case effort has proven so many inconsistencies and deceptions, it is now at a sacrifice of my constitutional rights. We have had numerous hearings that do nothing more than allow the state room for circumlocution of the fact that there is no evidence for probable causes indicated to accommodate the totality of circumstances in the affidavit. In my motions, I'm trying to address these 3 issues: tracking issues that are common sense with expert testimony, officer discrepancy between Stephen German and David Bowman depositions, and discrepancies in multiple courts between judges and Officer Stephen German.
Let me see if I understand preliminarily, Mr. Richards. You're saying that throughout all of the course of this litigation, the state has refused and the court has not ordered them to produce evidence that you believe is necessary for there to be probable cause for the case to go forward. Is that?
Yes, and the reason is because of Savalongo versus State. We did find that the affidavit in this case to be sufficient on its face, and I understand how it's sufficient. It meets all the requirements of a search warrant. The problem is it shows nothing. You can plug anybody's name, anybody's address into it, and as long as you get lucky fishing, that warrant is good. I mean, we have to do a discount double check. So as far as the deference goes, we give deference to officers on good faith if they're not lying. And I totally understand that, but we have found deceptions from this officer. We have found lies, and they were not presented at the Frank's hearing. Tony Tomas was just arguing that the fact that the evidences to the marijuana sales were omitted, I should be able to see the evidences. Well, I haven't proven the burden of a lie. I have handouts of the discrepancies. I don't know if you want to
Yes,
see them, Your Honor.
sure. Do you have a copy for the state?
Yes, I absolutely do. Grab one here. I was going to ask that next. Here we go.
Okay, thank you.
So basically, Officer German says that he got the CI from David Bowman. David Bowman specifically says that he had nothing to do with the sales. He doesn't know if it was an undercover agent or a CI. And he was security around the corner. I mean, this is major reasonable doubt. This shows that the officer is lying on the stand or is very, very wrong.
So what you have provided me are excerpts from depositions, is that correct?
Yes, Your Honor.
And how does this support the motion to compel?
This supports it because in the Frank's hearing, I'm going to read this, Strickland versus Washington, which comes from United States versus Bagley, the court held that a new trial must be granted when evidence is not introduced because of the incompetence of counsel only if there is reasonable probability that, but for counsel's unprofessional errors, the result of the proceeding would have been different. Now, he just fought the fact of omission. I'm fighting that this officer actually lied on the stand. I have proven that burden. I have the right to see this evidence because there is no good faith with this officer.
Now, this evidence being what?
He lies about where he got the CI.
Right, but I'm saying we're talking about a motion to compel, and I understand what you're saying about the officer's evidence being flawed, but what is it that you're asking me to compel from the state?
I am trying to compel and from the affidavit from the marijuana sales, I want pictures of marijuana allegedly procured for claim in this affidavit, pictures of test kits purportedly used to verify these alleged products purchased and previously denied dealing with preposterous tracking issues, and receipts for CCSO funds dispersed in December 2015 for alleged sales transactions, documenting the alleged investigation.
Now, these things were not turned over in discovery by the state to your former counsel at any point?
No, due to the burden I failed to meet from the Frank's hearing on November 22nd, 2019.
Okay.
And other October 20th tracking discrepancies.
And you believe that these items you just mentioned should be compelled so that it would support your motion to dismiss based on lack of probable cause?
Yes, Your Honor. This officer lied.
Okay. Additional comments, Mr. Richards?
Yes, as far as the omissions go, I'm sure, the judge signing the search warrant, and this is, I'm just gonna, for the motion to compel. When he went to Judge Pivacek, he claims, let's see here, from his incident report, he says he developed probable cause. he never says he showed the state's attorney representative that he doesn't know who that state's attorney representative is. And he doesn't say that he showed Judge Pivacek this evidence. He just says that he showed the state representative and Judge Pivacek the search warrant affidavit, which she approved on face value, which I'm not arguing the face value. What I am arguing is that he never showed evidence. There was never evidence returned to Judge Pivacek. In Stephen German's depot, page 5, line 23, Rex Darrow actually mentioned it on September 27th, 2017. I'm going to start page 5, line 23.
Judge, does the defendant have copies of these deposition transcripts for the state or defense? I've never received any. I requested copies if any were ordered from the court reporter. Never received any notice that they had been disclosed. And I'd like the court to also be able to see the entire transcript instead of a blurb with a handwritten note on top of it.
I may, if necessary, compel that from Mr. Richards, but for purposes of the motion hearing right now, let me just hear his references.
I'm okay with getting his deposition transcripts. Rex Darrow gave me these depositions, so I'm going off of that. I don't know why. I don't know what he was supposed to do.
But go ahead and just make the references, Mr. Richards, and we'll deal with the state's request separately.
And I don't object to any time needed to do whatever. Okay, that's fair enough. Okay, were you present when the controlled buy was done? He said I was. Okay, did you prepare a report as a result of the controlled buy? I believe I did, sir. Do you know if he provided that to the state? I do not know, sir. So, you know, he's alleging charges without the evidence, and he doesn't know where he filed them. So, it's just, I mean, there's just too much reasonable doubt. Then on top of that, as far as the omissions go, I'm going to read a little bit, just 2 sentences from Frank. Frank sets forth the standard of analysis for false statements contained in an affidavit for search warrant. To warrant an evidentiary hearing on a motion to suppress based upon this statement in an affidavit, there must be allegations of deliberate falsehood or reckless disregard for the truth, and those allegations must be accompanied by proof. Allegations of negligence. And then Florida appellate courts have held that in order to meet the Frank's test under Johnson, police conduct must rise to the level of hoodwinking or bilking, duping the issuing judge or magistrate into signing the warrant. So, I'm sure Judge Pivacek would not have signed this warrant if she knew that Stephen German, under in court, would call this a statement as well. I mean, that's calling it a statement in one court to protect yourself from due process of a defendant in another court. It just seems very unethical. So,
Mr. Richards, you're saying that if I order the state, if they have it, to produce these items 1 through 4, that will support your motion that there should be a dismissal due to lack of probable cause because of the deficiencies or the omissions from the search warrant affidavit?
The omissions and
false statements and false statements?
Yes, and those false statements, absolutely. And it's not just those statements. I mean, everybody, literally everybody in the courtroom. And,
now, essentially, what's the nature overall of the false statements? What is it that they falsified?
They alleged me of marijuana sales in a search warrant affidavit. And the reason it wasn't a search warrant affidavit is because the evidence doesn't exist. If it existed, I believe he would have gotten an arrest warrant. So it doesn't matter what happened in the search warrant. The search warrant would have just been.
What about the confidential informant allegations in the affidavit? Why is that not sufficient?
The confidential informant, because the confidential informant, do you mean as far as the CI being confidential?
Well, as I recall, the affidavit in support of the warrant that Judge Pivacek signed, it alleges that a confidential informant made within 30 days of the search warrant being executed purchases from you at that residence.
Yeah.
Why wouldn't that be enough to?
Well, the problem with the confidential informant, now, when I had Rex Darrow, he sent me a motion to compel the confidential informant. I was willing to do this under the circumstances that I want the evidence from the marijuana sales with the confidential informant. I mean, if I compel just a confidential informant, anybody can get up on the stand and say anything. So that's, that's all I've been dealing with hearsay. So, I mean, if you give me the CI with the evidence, I won't argue to that at all.
Additional comments about the motion to compel before I hear from the state on that?
Yes, like I said, if you go to my motion to dismiss under part 2, there's tons of lack of verifications. I mean, everybody in the courtroom doesn't know if it exists. Jim doesn't know if it exists. Rex Darrow on September 17th doesn't know if it exists.
If what exists?
The evidence relating to the marijuana sales in the affidavit, Your Honor. So, I mean, even the state, Mara Marzano didn't check the box for information available to a CI in this case. The substitute state's attorney couldn't verify the existence of probable cause evidence during the September 27, 2017 hearing. And on November 22nd, even the state assumed the existence of probable cause evidences. So, I mean, it's not just Stephen German. It's a whole. Nope, it's just reasonable down everywhere, Your Honor.
Okay. Ms. Rumley, any comments on the motion to compel?
Yes, Your Honor.
Judge, the issue we're still discussing 5.5 years later, after Mr. Richards' original arrest, is whether there was probable cause for the signing judge to issue a search warrant based on an affidavit that was authored, I believe, by Sergeant Steve German, the Collier County Sheriff's Office. On September 30th, 2016, a motion to compel was filed by defendant's counsel. It was granted in part and denied in part by Judge Ryder on November 9th, 2016. She denied the request in the motion to compel for the name or the number of the confidential informant, for surveillance of the premises, conversations to which the defendant was a party if the confidential informant was a part of them, the dates and times of the CI activities, the dates and times of the CI interview. And as Your Honor has already stated, you are correct. The basis of the search warrant affidavit in this case was 2 sales of marijuana conducted out of Mr. Richards' residence to a confidential informant within 30 days prior to the execution of the search warrant at Mr. Richards' residence. That motion to compel in September 2016 also requested the description, receipt, pictures, and legal documentation of CCSO investigative funds used for those CI buys. A dated description, receipt, pictures, and legal documentation of marijuana purchased by the CI. A dated description, receipt, pictures, and legal documentation of marijuana field tests for that marijuana that was purchased by the CI. Depositions involving debriefing